for people who are unhealthy and were able to get insurance, but perhaps not for the things that they were most concerned about, or only at very high rates, their rates will be lower under the system, even without the minimum coverage provision. Also, you have a large number of people who, under the Act...
Excuse me, why do you say I didn't follow that? Why?
Because
why would their rates be lower?
Their rates are going to be lower than they were under the prior system because they're going into a pool of people, rather than having some of whom are healthy, rather than having their rates set according to their individual health characteristics. That's why their rates are so high.
The problem, Mr. Farr, isn't it that they're going to a pool of people that will gradually get older and unhealthier? That's the way the thing works. Once you say that the insurance companies have to cover all the sick people and all the old people, the rates climb. More and more young people and healthy people say, why should we participate? We can just get it later when we get sick. So they leave the market, the rates go up further, more people leave the market, and the whole system crashes and burns, becomes unsustainable.
Well,
and this is not like what I think. What do I know? It's just what's reflected in Congress's findings, that it looks at some states and says this system crashed and burned. It looked at another state with the minimum coverage provision and said this one seems to work, so we'll package the minimum coverage provision with the non-discrimination provisions.
Well, in a moment I'd like to talk about the finding, but if I could just postpone that for a second and talk about adverse selection itself. I think one of the misconceptions here, Justice Kagan, is that Congress, having seen the experience of the states in the 90s with community rating and guaranteed issue, simply imposed the minimum coverage provision as a possible way of dealing with that, and if you don't have the minimum coverage provision, then essentially adverse selection runs rampant. But that's not what happened. Congress included at least half a dozen other provisions to deal with adverse selection caused by bringing in people who were less healthy into the Act. There are, to begin with, the Act authorizes annual enrollment periods, so people can't just show up at the hospital. If they don't show up and sign up at the right time, they at least have to wait to the time next year. That's authorized by the Act. With respect to the subsidies, there are three different things that make this important. First of all, the subsidies are very generous. For people below 200% of the federal poverty line, the subsidy will cover 80% on average of the premium, which makes it attractive to them to join. The structure of the subsidies, because their income, they create a floor for based on the income of the person getting the insurance, and then the government covers everything over that. And this is important in adverse selection because if you do have a change in the mix of people and average premiums start to rise, the government picks up the increase in the premium. The amount that the person who's getting insured contributes remains constant at a percentage of his or her income. And the third thing is...
There's nothing about federal support that is unsustainable, right? That is infinite.
Well, I mean, that's a fair point, Justice Scalia, although one of the things that happens if you take the mandate out, while it is true that the subsidies that the government provides to any individual will increase and they will be less efficient, I'm not disputing that point. Actually, the overall amount of the subsidies that the government will provide will decline, as the government notes itself in its brief, because there will be fewer people getting them. Some people will opt out of the system even though they're getting subsidies. But I'd just like to go back for one more second to the point about how the subsidies are part of what Congress was using, because the other thing is that for people at below 250% of the federal poverty line, Congress also picks up and subsidizes the out-of-pocket costs, raising the actuarial value. And so you have all of that, and then you have Congress also, unlike the states, establishing, or I should be precisely accurate, unlike almost all the states, establishing an age differential of up to 3 to 1. So an insurance company, for example, that is selling a 25-year-old a policy for $4,000 can charge a 60-year-old $12,000 for exactly the same coverage. The states, typically in the 90s, when they were instituting these programs, they either had pure community rating, where everybody is charged the same premium, everybody, regardless of their age, is charged the same premium. Some states had a variance of 1.5 to 1. Massachusetts, for example, which did have good subsidies, but their age band was 2 to 1. So when Congress is enacting this act, it's not simply looking at the states and thinking, well, that didn't go very well. Why don't we put in a minimum coverage provision? That'll solve the problem. Congress did a lot of different things to try to combat the adverse selection. Now, if I could turn to the finding, because I think this is the crux of the government's position, and then the plaintiffs pick up on that and then move from that to the rest of the act. And it seems to me, quite honestly, it's an important part because that is textual. You know, in this whole sort of quest for what we're trying to figure out, the finding seems to stand out as something that the court could rely on and say, here's something Congress has actually told us. But I think the real problem with the finding is that the context in which Congress made it. It's quite clear that if the court wants to look, the findings on page 43A, of the Solicitor General's severability brief in the appendix. But the finding is made specifically in the context of interstate commerce. That is why the findings are in the Act at all. Congress wanted to indicate to the court, knowing that the minimum coverage provision was going to be challenged, wanted to indicate to the court the basis on which it believed it had the power under the Commerce Clause to enact this law. Why does that make a difference with respect to finding I, which is the one that the government is relying on, and in particular the last sentence, which says this requirement is essential to creating effective health insurance markets in which guaranteed issue and pre-existing illnesses can be covered? And the reason is because the word essential in the Commerce Clause context doesn't have the colloquial meaning. In the Commerce Clause context, essential effectively means useful. So that when one says, in Lopez, when the court says Section 922Q is not an essential part of a larger regulatory scheme of economic activity, it goes on to say in which the regulatory scheme would be undercut if we didn't have this provision. Well, if that's all Congress means, I agree with that. The system will be undercut somewhat if you don't have the minimum coverage provision. It's like the word necessary in the necessary proper clause. It doesn't mean, as the court has said on numerous occasions, absolutely necessary. It means conducive to, useful, advancing the objectives, advancing the aims. And it's easy to see, I think, that that's what Congress...
Any dictionary that gives that...
I'm sorry,
that
Justice Scalia?
definition of essential, it's very imaginative. Just give me one dictionary.
Well, but I think my point, Justice Scalia, is that they're not using it in the true dictionary sense.
How do we know that? When people speak, I assume they're speaking English.
Well, I think that there are several reasons that I would suggest that we would know that from. The first is, as I say, that the findings themselves, Congress says at the very beginning, the head of it is Congress makes the following findings, and they're talking about the interstate commerce. B is headed effects on the national economy and interstate commerce. So we know the context that Congress is talking about. It is more or less quoting from the Court's Commerce Clause statements. But if one looks at the very preceding finding, which is finding H, which is on 42 over onto 43, Congress at that point also uses the word essential in the second sentence. It says this requirement, and again we're talking about the minimum coverage provision, is an essential part of this larger regulation of economic activity, which is, by the way, an exact quote from Lopez. in which the absence of the requirement would undercut federal relation, also exact quote from Lopez. But what it's referring to is an essential part of ERISA, the National Health Service Act, and the Affordable Care Act. It can't possibly be, even the plaintiffs haven't argued, that those acts would all fall in their entirety if you took out the minimum coverage provision. And as a second example of the same usage by Congress, the statute that was before the court in Raich, Section 801 of Title 21, the court said that the regulation of intrastate drug activity, drug traffic, was essential to the regulation of interstate drug activity. Again, it is simply not conceivable that Congress was saying one is so indispensable to the other, the way the United States uses the term here, so indispensable that if we can't regulate the intrastate traffic, we don't want to regulate the interstate traffic either. The whole law criminalizing drug traffic would fall. So I think once you look at the finding for what I believe it says, which is we believe this is a useful part of our regulatory scheme, which the Congress would think in its own approach would be sufficient.
Counsel, the problem I have is that you're ignoring the congressional findings and all of the evidence Congress had before it that community ratings and guarantee issuance would be a death spiral. I think that was the word that was used, without minimum coverage. Those are all of the materials that are part of the legislative record here. So even if it might not be because of the structure of the Act, that's post hoc evidence. Why should we be looking at that as opposed to what Congress had before it and use essential in its plain meaning? You can't have minimum coverage without what the SG is arguing, community ratings and guaranteed issue. You can't have those two without minimum coverage.
Well, I think that's a fair question, but the idea that all the information before Congress only led to the idea that that you would have death spirals seems to me to be contradicted a little bit, at least, by the CBO report in November of 2009, which is about 4 months before the Act passed, where the CBO talks about adverse selection. Now I want to be clear. This is at a time when the minimum coverage provision was in the statute, so I'm not suggesting that this is a discussion without that in it. But nonetheless, the CBO goes through and talks about adverse selection and points out the different provisions in the Act, the ones I've mentioned, plus one other, actually, where in the first 3 years of the operation of the exchanges, those insurance companies that get sort of a worse selection of consumers will be given essentially credits from insurance companies that get better selection.
Do you want us to write an opinion saying we have concluded that there is an insignificant risk of a substantial adverse effect on the insurance company? That's our economic conclusion, and therefore not severable. That's what you want me to say?
Doesn't sound right the way you say it, Justice Kennedy.
But you don't want them to say either that there's a death spiral. You don't want us to make either of those two findings, I'm assuming.
That's correct. No, I agree that there's a risk. The significance of it, people can debate. But what I think is lost in that question, and I didn't mean to be whimsical about it, I think what is lost in a little bit is what's on the other side, which is the fact that if you follow the government's suggestion, if the court follows the government's suggestion, what is going to be lost is something we know is a central part of the Act.